Creditors, when a financial restructuring heads south. Previously, I've blogged about the personal bankruptcy process in Canada and the corporate bankruptcy process in Canada. I also wrote about the three types of bankruptcies in Canada. From the first two, the personal bankruptcy process and the corporate bankruptcy process, that was from the perspective of a person or a company filing an assignment in bankruptcy. I also wrote about a person or company being pushed into bankruptcy by one or more creditors through a bankruptcy application and a bankruptcy order. Today's blog is to talk about the third type of bankruptcy, and that's a deemed assignment in bankruptcy, most commonly associated with when a financial restructuring under the Bankruptcy and Insolvency Act heads south. So that is what I'm going to be talking about, the deemed assignment in bankruptcy. Now in Canada, very large corporate restructurings are done under the Companies Creditors Arrangement Act. A person or a company of any size can also restructure under the Bankruptcy and Insolvency Act, or commonly known as the BIA. This blog is about restructuring under the BIA to illustrate the third way a person or company can go bankrupt through a deemed assignment in bankruptcy. So, the reason people or companies would file for a financial restructuring is to get a time out from its creditors taking action against them trying to collect on debts. People who owe $250,000 or more and companies who have too much debt need a timeout to formulate a plan for settling their debt. If a person owes less than $250,000, then there's a different provision of the BIA available, but that ultimately does not end up in being a deemed assignment in bankruptcy, and that's really the topic of this blog. So the BIA has a financial restructuring section. The debtor needing a timeout can either file their restructuring proposal straight away or first buy some extra time by filing a notice of intention to make a proposal. If a debtor first files a notice of intention to make a proposal, within 10 days after that, they need to file a cash flow statement in the prescribed form, plus related extra documents. Unless the time period is extended by the court, the restructuring proposal must be filed within 30 days after the filing of the notice of intention to make a proposal. When a debtor files the actual restructuring proposal, a cash flow statement has to be filed with it as well, be it an original one if the debtor goes straight away to filing the proposal, or an updated one if they first filed the NOI. Once filed, the trustee must notify the creditors of the filing of a notice of intention to make a proposal and the restructuring proposal. The trustee must call a meeting of creditors within 21 days of the filing of the restructuring proposal. The creditors get to vote to approve or not approve the restructuring proposal. Creditor acceptance is by voting and must be in the requisite majority, calculated as a simple majority in number and at least 2/3 of the dollar value of all claims voting either in person at the meeting or by proxy and voting letter delivered to the trustee prior to the start of the meeting. After creditor acceptance, the trustee must get the restructuring proposal approved by the court. For the court approval process, the court considers if the restructuring proposal are the terms of the restructuring proposal fair and calculated to benefit the general body of creditors? Did the trustee properly follow all required procedural steps, including properly holding and counting the voting by the creditors? As long as the answers to these questions are yes, and the restructuring proposal took the interests of all stakeholders into account, then the court will approve the restructuring proposal. Then the company or the person must successfully complete it, including making all payments required under the restructuring proposal. How can a restructuring proposal fail or head south? A financial restructuring plan under the BIA can fail if the person or company fails to file the required cash flow statement and related documentation within the 10-day period after the filing of the notice of intention to make a proposal, or the debtor fails to file a financial restructuring proposal within the 30-day time limit after the filing of the notice of intention to make a proposal, or such greater time period authorized by the court, or the requisite majority of creditors voting do not accept the restructuring proposal, or the court does not approve the restructuring proposal, or the restructuring proposal is accepted by the creditors and approved by them, but the debtor fails to make the payments and do any other things contained in the restructuring proposal. Under the following situations, the person or company will be deemed to have filed an assignment in bankruptcy if the person or company fails to file the required cash flow statement, the debtor fails to file the financial restructuring proposal on time, the requisite majority of creditors voting do not accept the restructuring proposal, or the court does not approve the restructuring proposal. Under any of these conditions, the person or the company is automatically deemed to have filed an assignment in bankruptcy. For the personal bankruptcy process, you can go back and review my earlier blog. And for what the corporate bankruptcy process is, you can do the same thing. When the restructuring proposal is accepted by the creditors and approved by the court, but the debtor fails to make payments or do any of the other things contained in the restructuring proposal, unlike the other events of default, there is not an automatic deemed assignment in bankruptcy. Rather, the trustee has to give notice to the debtor, and if there are any, the inspectors in the restructuring. The person or company attempting to restructure then has 30 days to remedy the default. If they do not remedy the default after the 30-day period, then the trustee has to issue a notice of default which is sent to the debtor, the creditors, and the superintendent of bankruptcy. After giving notice of default, the trustee does not have to do anything else. Any creditor can then bring a court motion to annul the restructuring proposal. If the trustee has the funding to do so and is directed by the inspectors, the trustee can also bring that motion. If the motion is brought and is successful, then and only then is the company deemed to have filed an assignment in bankruptcy. But if nobody brings the motion, the company actually just floats out there, and the trustee is entitled to go for taxation of its receipts and disbursements, make whatever distribution it can with the funds on hand, and then go get its discharge. So to recap, the three types of bankruptcies in Canada are filing an assignment in bankruptcy, a bankruptcy application and the issuance of a bankruptcy order, and as explained in this blog, a deemed assignment in bankruptcy. Creditors.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting over, starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now.
Oh.